Good afternoon, Your Honour.
I'm sorry for the slightly delayed start. A bit of disorganization on my part, I'm afraid, but we're now all set and on deck. And as I understand it, for the claimants, it's Mr. Dylan Malone, and for the defendant, Mr. Alexander Barrell.
Yes,
I think I have that right.
Yes.
Good. Now, the index to the bundle is agreed. And,
I think
we need it. We're going to need an e-bundle, and so the parties must cooperate in establishing an e-bundle. Now that leads on to the question of the modality of the hearing. I have considered whether or not some of the court facilities could be used, the courtroom or a court meeting room, with one or two or maybe more witnesses nonetheless giving their evidence in a virtual way. Now, the problem with that proposal is that it does not allow for public streaming. And I think it's most important, pursuant to principles of open justice, that these virtual trials be available to the public by having a facility for interested people to observe through clicking on the various links the proceedings. Last week, I had a 4-week trial in a Dubai matter, in a DIFC matter, using Microsoft Teams organized by the DIFC court. And it went extremely well. And I think, having regard to various logistical difficulties in using the courtroom or the courtroom facilities, and having regard to the principle of open justice, that we should adopt the Microsoft Teams facility for this trial. Now, before I make an absolutely final direction, both of you will have heard the way my mind is working. Are there any serious sustainable objections to what I have proposed, Mr. Dylan Malone?
Thank you, Justice Field. No, not at all. In fact, Mr. Barrell and I had been in touch over the weekend, and it did seem, for the reasons you mentioned and others, that probably that was the likely sense and best way of arranging matters. So we have no objection on our side.
Mr. Barrell?
Yes, Your Honour, Mr. Dylan Malone is quite correct. No objections from our side either. So happy to progress on a full virtual trial via Teams. The only one, I'm not sure if the facility that was adopted, Your Honour, during your 4-week trial. I wonder if the only point I'd make is one thing that I have found particularly useful is having a document controller or of sorts. I'm not sure if the DIFC courts run that sort of facility during the trial, so that when a document is referenced, it comes up very, very easily, especially in document-heavy cases such as this. If that's not feasible, either way, it's not the end of the world. I just wondered if that is a facility that's offered through the DIFC courts.
Well, we have something called case lines, and it is very easy to be taken directly to a specific page in the e-bundle. Very easy.
Okay, well that makes sense. Thank you, Your Honour. No objections for our side at all. I think we
Right.
agree that progressing as you suggested is
Right.
the most appropriate course.
Very good. Well, then, on this basis, of course, any legal representative or any witness will obviously appear virtually through the Microsoft Teams. Now, my experience suggests this, that where possible, a witness should give his evidence from the office of the lawyers representing the party on whose behalf the witness is giving his evidence. Now that, of course, requires that the witness be presumably in Dubai, preferably in the DIFC, but in Dubai, so that the witness would have access to the offices of the solicitors for the various parties. What one needs is a basic protocol as to who, if anyone, will be in the room when the witness is giving evidence, and how an oath is taken. Many witnesses in our court are Muslim and prefer to take a religious oath on the Quran. And so a copy of the Quran should be available wherever the witness is going to be located when he or she gives evidence. Now, it's not only the Quran. I've had a request for the Hindu holy book. And of course, if someone wants to take a Christian oath, the New Testament or the Bible as a whole, and I think Jewish witnesses would be prepared to swear on the Old Testament. So please, each side make inquiries of their witnesses as to how they would like to take the oath. Of course, they're entitled to take the secular oath of affirmation. I will administer the oath, but we all ought to know in advance what oath is going to be taken so that the necessary holy books can be provided. As to who should be in the room while the witness is giving evidence, it would be far better if there is no one in the room, but reasonably close by, there's someone with good technological skills in case there's some technological problem. Now, experience also suggests that it would help a lot if the witnesses were educated into case lines. It's terribly simple. Even I, who have no technological skills whatsoever, have mastered case lines, and in particular, how to find a document. Counsel should give the reference to the document. The e-bundle will probably be divided into sections, alphabetical sections. And so the reference will be whatever the alphabet section is, let's say it's H, and then the page number. And if that is inputted in the Find the Page facility, lo and behold, up on the screen comes the document. It will, if the witnesses are not well educated into case lines, then they're going to need hard copies of these many documents, which would be a great shame for the forests. And it could lead to some logistical difficulties, providing all these hard documents to the various witnesses. So can I take it, starting with you, Mr. Dylan Malone, that you will use absolute best endeavors to ensure that your witnesses can handle case lines on the CMS system?
Yes, indeed. Thank you, Justice Field. 100%. We're in the fortunate position of having 3 of our 4 witnesses who will be in Dubai, and we will have separate rooms for them here in the offices of Al Tamimi, which will be separate, and nearby Mr. Besiso, who will be able to assist them if needs be. But their case lines screen will be linked to everybody else's case lines navigation, and therefore we hopefully will not have any difficulties. Mr. Allen will be in Edinburgh, I think.
Yes.
And he is the quantum and delay expert on our side. So we will go through the system with him. He has given evidence before, and he's familiar with the documents, obviously. So I hope very much that he will equally have no difficulty at all in complying with your directions.
Fine. That's good. Mr. Burrell?
Yes, yes, Your Honour. I think the defendant's position is in fact extremely similar again to the claimant, in that I think two of the witnesses are in Dubai. One is not. Mr. Rohit is in India, but it's again a similar position to Mr. Dylan Malone, in that we will ensure that the case line system is fully explained, and we'll ensure that all of the oath information is obtained beforehand as well. So yes, we can ensure that the witnesses give evidence, are familiar with case lines before they give their evidence.
Good, but thank you very much. You presumably will be in the UK, Mr. Burrell.
I will, yes, Your Honour.
Yes, as I will be. Yes. Right, good. We're making good progress. Now, estimated length of trial. There's been some debate in the correspondence, which I'm privy to, about 3 days, 4 days, and the like. Now, at the moment, it looks as if, just give me a minute, I'm turning up my diary. It looks as if 3 firm days are in the diary. The trial beginning on the 20th of September. That's a Monday. And then the next day and the following day, the 22nd. Now, I hope I'm on the same page as everybody as far as these dates are concerned.
Yes.
Good. Now, I think the question is whether we should reserve a 4th day as a contingency day.
Yes.
And namely
yes.
Namely Thursday the 23rd. And I can tell you now, in the case of this factual complexity, that I shall want written closing submissions. And so are we all agreed? And if Mather, you're listening to this, I take it?
Yes, Judge, I'm here.
Oh, thank you. I should have said good afternoon to you too. It's very nice to have you in charge of us all.
Thank you.
Mather, are we okay from the registrar's point of view to have the 23rd, Thursday the 23rd, assigned to us as a possible overflow day?
Yes, Judge, it should be fine.
Okay.
Yes.
Well, I'm again, I'll ask counsel for each side for their acceptance or not of what I've just proposed. Mr. Dylan Malone.
Yes, thank you very much, and I'm very grateful to the court for reserving and making that day available. Again, Mr. Burrell and I have had some discussion over the weekend, and we've narrowed the estimate somewhat by agreement. I think we are agreed, subject to you, that openings are probably not necessary or required, and both parties are agreed that we can get into the evidence directly, subject to you. Secondly, we are agreed that, given also your indication, especially that written submissions would be on the evidence and the law post-hearing would be required as we anticipated, that we wouldn't take up the court's time with closing submissions either. And that in that circumstance, I think 3 to 4 days was my estimate. We're sticking with that on our side, and we believe that's achievable with a good wind. There was one aspect that I might mention now, which is I've also discussed this morning with Mr. Burrell, which is in these cases of expert delay in quantum and construction cases, it may be helpful to the court and to make provision in the timetable for a short presentation by the quantum and delay expert on each side by way of PowerPoint at the commencement of their evidence. That is something that has come from our side, from Mr. Allen himself. He was recently in an arbitration in Doha, where he found that to be of assistance to the tribunal. And I have discussed it with Mr. Burrell this morning, and I believe he was taking instructions and may not be in a position to agree to that now. But if the court were agreeable to that, mindful as we will be as the parties, that we will adhere to the, we will be conscious of the time, and that it would be kept to a very tight presentation. Perhaps that's something the court might consider directing.
Well, I'm all for it, as long as the overall time is not extended and we can comfortably finish before the end of Thursday, the extra day. And I think that would be helpful. It shouldn't be over long, but from my point of view, a short presentation of that nature, I think, would be helpful. Mr. Burrell, your observations?
Yes, Your Honour. Sorry, just briefly to confirm in relation to the earlier point. Yes, we agree 1 day in reserve would be entirely appropriate, and written closings also appropriate given the nature of the case. Similarly, as I can confirm what Mr. Dylan Malone stated earlier in relation to openings or the lack of openings as well. Yes, in relation to presentations, I think I'm still taking instructions to get a completely authoritative position, but my understanding is we're happy to go ahead with presentations if Your Honour considers them helpful. We would request that they be limited, though, in time, just so that we can stay on track. But my understanding is that's what everyone else is in agreement with as well.
Okay. Now, I'm not directing or compelling either side to have their expert or experts do a short presentation. It's a matter of choice by each side. As far as I can see at the moment, it's likely to assist me. But if one side, for instance, if Mr. Burrell's side were to decide that it's not worth the candle and they would prefer not to, that's fine by me, and no inferences will arise because of that course of action. So we'll leave it there. The last thing on my agenda is a timetable for the trial itself. I don't think there is one at the moment. I may have missed it if there is, but if there isn't, the two of you should do your best to map out how the time is to be distributed over the various presentations, both by counsel and by the witnesses. Just before I give way to counsel, because this is it's a public hearing, I would like a sort of 6-minute opening from each of you, just giving the general nature of what the dispute is. You don't have to go into any documents. You don't have to name any particular witnesses, but just to describe a little bit of the background, what is really at the heart of the dispute, and a sentence or two as to the position adopted by the claimant and the position adopted by the defendant. No more than 6 minutes. Is that understood?
Yes, thank you.
Yes, Your Honour, that's a helpful indication. Thank you.
Anything else on the agenda?
Yes, Justice Field, if I might just quickly, I think it should assist. I have a little note here of what is expected of us between now and the trial, and there's just a few milestones. If I might just mention them in sequence.
Yes, by all means.
Thank you. Tomorrow, the trial bundle will be filed. That's the 6th. Then on the 9th, you're expecting a supplemental report from Mr. Richard Paul of Savills.
Yes, that's right. I remember that. Yeah.
That's on Thursday. Then the chronology will be with you on the 13th.
Yep.
The skeletons, by our calculations, are due on the 14th.
Yep. Now,
And then,
they are mutually exchanged, if I remember. They're not sequential. Is that right?
That's correct.
Yep.
And then on the 16th, we're due to give you the reading and timetable. Now, I think the 16th is a Thursday. And I wondered, especially you are in the UK and etc. We might, an extra day just might help us there on, if we could say Friday the 17th. That's our proposal, which I haven't discussed with Mr. Burrell.
Well, if the two of you agree to bring it forward a day, that's fine. But if not, it'll be the day that's currently on the agenda.
Yes, it's the clear day rule.
Yeah.
Yeah.
Well, if you want to improve on the clear day rule by agreement, that's fine.
Fine, thank you.
If you can't agree, we'll just abide by the clear day rule.
Thank you. And then in relation to the actual sequence of evidence at trial, subject to the court, for us, the claimant, it will begin with Mr. Resk and then Mr. Prajiev, followed by Mr. Allen, who will begin his evidence on delay or begin his cross-examination on delay, and then on quantum, because he's both delay and quantum. But he'll take the stand once rather than twice.
Yeah.
And then Mr. Paul. And for the defendant, first Mr. Kurdi, second Mr. Singhal, again delay first, then quantum, and then lastly Mr. Firdas.
And those sequences are all agreed.
From the defendant's side, sorry, Your Honour, I think that that general order is agreeable. I suppose the only point to make, and I suppose it's slightly different because it's a court setting, whether the court would find it helpful to have just the factual evidence first from all the factual witnesses and then progress to the experts. But I don't think there's any strong position either way from the defendants. We're happy for the schedule as set out by Mr. Dylan Malone.
All right, well, let's go with the sequence that I've heard of from Mr. Dylan Malone.
Thank you,
Your Honour. Yes.
I shall be doing, as you can imagine, a fair bit of pre-reading, and so the basic factual framework will be reasonably clear to me.
Thank you very much, Justice Field.
Any other business, gentlemen?
There was just one aspect which the court may have. So I should ask Mr. Burrell if he has anything first, probably.
There's nothing further from our side. Thank you.
Right, thank you very much. Yes.
There's one. I'm sorry, Justice Field. There's just one contentious aspect which you may have seen in correspondence over the last few days, and I just want to raise it here. In all likelihood, we'll be further addressing it in correspondence later today. It just arises from this sensitive issue of the contingency or deferred fee agreement structure that the defendant has in place, which only very recently came to light. And I just mention it here to say that we will be probably engaging in further brief correspondence on it later, and that we wish to strictly reserve our client's position in respect of those arrangements.
Well, it was only today or yesterday, I think probably today, that I became aware that there was a funding agreement, if I can give it that neutral term, And this is something quite new to me. As far as I'm aware, I have not presided over a trial where one of the sides is funded, where there's third-party funding. And so copy me in to open correspondence that is passed between the two sides. We've got a bit of time before the trial starts. And if you need a judicial decision on anything, then the earlier you alert me to the problem that hasn't been agreed, the better.
Very much appreciated, Justice Field. I believe it's more a question, if I can jump the gun a little, just in ease of you and Mr. Burrell. I think it's probably more a question of us putting our position on the record rather than requiring any decision.
Okay.
I think that's probably the nature of it.
Yes, okay. Fine. Well, I might also have a word with the registry as to any experience that the registry has of the occurrence of third-party funding in DIFC litigation. They may be able to give me a little bit of background, but neither of you be bothered about that. That's for me to have a conversation or two with Mather and the deputy registrar. Well, I know that Dubai is lucky enough to have Sunday as a working day, so I wouldn't want to keep you from your work from now on. I shall be adopting a different course, but I think we can wrap this up, can't we?
Thank you very much, Justice Field. We're very grateful.
Thank you, Your Honour. Yes, thank you.
Good. Fine. Thank you very much. I shall close things down now. Thank you.
Thank you.